Hello, everyone. This is a lecture podcast for LAWS12070, Republic, International, and Human Rights Law. Our topic for this week's podcast is on jurisdiction. A lot of us would have an idea about what jurisdiction is, mainly because we would have a sense that we are subject to the laws of Australia. And we know, therefore, that by being residents and citizens and subjects of Australia, we are therefore subject to the jurisdiction of Australia. And without even having to think about this notion of jurisdiction or the power of the state of Australia over us, we simply know intuitively that we need to obey its laws and that the Australian Parliament could pass laws that would apply to us to such an extent that we may even have come across the Latin maxim, ignorantia legis non excusat, or ignorance of the law excuses no one. And the sense that we have about jurisdiction is that as citizens of Australia, the state of Australia, mainly, for example, through the Commonwealth Parliament, it can make laws that apply to us. And in fact, the power of the Australian Commonwealth Parliament to pass laws is almost unlimited. It's only limited by whatever is not permitted by the Australian Commonwealth Constitution, for example, as well as by the inherent principles in the constitutional democratic government which we have, which recognizes a partial separation of powers. And to that extent, therefore, those act as constraints on the power of the Australian Commonwealth Parliament to pass laws. But otherwise, if the Australian Parliament, for example, decides that it will be unlawful for people who are below the age of 20 to engage in sex, or even to prohibit marriages of people who are less than 20 years old, that is something that is within the power of the Commonwealth Parliament to legislate. Again, only for the purpose of emphasizing that part of the powers of the Australian state, as demonstrated by the Australian Commonwealth Parliament, is to make laws that apply to us. And at the same time, its power to make laws is also related to another power, and that is the power of the Australian state to enforce those laws to us, to make sure that those laws apply to all its subjects. And the other dimension of state jurisdiction refers to the fact that if we end up violating those laws, then especially if it is in relation to criminal laws, then the Australian state, through its courts, has the power to try us for violations of its laws. Now, the bigger question that is often asked is, given the fact that we know that the Australian state has jurisdiction over us because we are its subjects and we live within its territory, the question is, does the jurisdiction of the state, is the jurisdiction of the state limited and bounded by its territory? Meaning, would a state, for example, still have the power to apply its laws to people who live outside of Australia? So in other words, can there be an extra territorial jurisdiction of states? And this is a question that we will be examining. And in particular, the question that we will need to examine is whether or not a state's laws can apply, for example, to its subjects who live abroad. And at the same time, can they also apply to non-subjects for acts that are also committed abroad? And so that is the focus of this lecture podcast on jurisdiction. And after studying this topic, you should be able to discuss and explain the meaning and nature of jurisdiction and the principles on which jurisdiction is based. Now, we have some familiarity with the concept of jurisdiction, especially for those who've probably had a chance to study criminal law or probably even civil procedure. And the sense that we have about jurisdiction is that it pertains to the power of a court over a person or over a subject or over a property or over a subject matter. Now, in fact, jurisdiction is often used and understood in many ways. And for example, the High Court in Lipuhar versus the Queen stated that the term jurisdiction here, as elsewhere, gives rise to difficulty because it is a generic term and used in a variety of senses, some relating to geography, some to persons and procedures, others to constitutional and judicial structures and powers. Now, we need to emphasize that in relation to international law, the notion of jurisdiction is broader and it refers to the legislative, administrative, and judicial power of a state to govern and control persons and property. Now, we're going to be digging deeper into these concepts in this lecture podcast. Lord Macmillan had the occasion to describe jurisdiction in Compañía Naviera Vascongado versus Steamship Christina, or the Christina, and he said that it is an essential attribute of the sovereignty of this realm, as of all sovereign independent states, that it should possess jurisdiction over all persons and things within its territorial limits. So it is a basic principle of international law that a state has sovereignty, has territorial sovereignty and jurisdiction over all persons and things within its territorial limits. And to such an extent that other states actually have no power to interfere with the exercise of by a state of its jurisdiction within its own territory. And that is mainly because there is also a principle against non-interference, as well as the principle against the use of force by other states against another state. And so that what is crucial, therefore, is that given the notion of territorial sovereignty, there is an acknowledgement in international law that states are supreme, are sovereign, and all-powerful, and have absolute authority and power in relation to whatever laws that it may pass within its own territory that apply to all peoples and subjects and things within its own territorial limits. And it is not for any other state to dictate, it is not for any other state to even try to influence the exercise of the territorial sovereignty by another state. Because the simple implication is that if another state is able to influence or even interfere with the exercise of territorial sovereignty of another state, then that state against whom influence or interference has been applied can no longer be sovereign, because sovereignty means being supreme in whatever that entity or state is able to do. Now, the bigger, even though Lord Macmillan pointed out that territorial sovereignty is in fact one of the essential attributes of a state, as we will know, state jurisdiction, and as we will examine in this lecture podcast, state jurisdiction is not in fact limited to the territorial limits of a state. And as we will see, it is in fact permissible for a state to try to apply its jurisdiction outside of its own territory. And that's one of the curious aspects that we are going to examine. In particular, we will try to determine, for example, whether or not, so for one, we know that it is permissible based on the nationality principle that we will examine. It would be permissible for a state, for example, to pass laws that would apply to its citizens who may end up living abroad or who may end up doing certain things or activities abroad, which means, therefore, that it is outside the territorial boundaries of a particular state. And yet, it is a recognized principle in international law that the laws of a state may reach outside of its own territory for it to then apply to its own subjects. So that's according to the nationality principle. But the other question that we can ask is, would it, for example, be permissible for the laws of a state to apply to its non-national, to those who are not its own nationals? So let's say for Australian laws to apply to somebody, for example, who is an Ethiopian citizen or who is a Canadian citizen who commits acts in Canada or in Ethiopia or outside of Australia that have a detrimental impact, for example, on the safety or the security of Australia. So the question is, would it be permissible, for example, for Australia to pass laws that would make persons liable for undertaking action outside of Australia if those actions have an effect on the safety and security of Australia? So that's one question we will have to examine. And would it even be possible, for example, for a state to pass laws that would criminalize behavior or that would punish behavior that has no direct impact on the state itself? So, for example, what if somebody commits genocide, such as in Syria or in Iraq or even in Afghanistan? Would it be permissible, for example, for the United States or Australia or some other country or some other state to pass legislation that would criminalize genocide or the slave trade, even if these activities occur outside a state's own borders? So again, going back to the question of jurisdiction. And we may also ask questions about would it be possible or would it be permissible for a state to pass legislation that would make a foreigner who commits acts against so this time it's going to be acts against the nationals of its own state, if those acts are actually committed again outside of its own territory. So for example, in the case of Australia, would it be permissible in international law for the Australian Parliament to pass a law whereby somebody who commits a tortuous activity or a harmful activity against an Australian, say in Ethiopia or in Nigeria, that harms an Australian citizen, would it be permissible for the Australian state to make such a person who commits harm against an Australian subject to its jurisdiction? And you will notice in that case, in the example that I gave, that the harmful act occurs outside of Australia, and the perpetrator of the act is not an Australian citizen as well. And the actions, for example, in the scenario I gave, have no direct impact on Australia as a state. So the question is, would international law permit the extraterritorial exercise of a state's jurisdiction? So these are some of the questions that we seek to examine, in particular, in this lecture podcast. Now, so what this tells us is that as far as the exercise of jurisdiction is concerned, there are actually three aspects that are recognized in international law. So international law recognizes that a state has the jurisdiction to make laws that apply to us as its subjects, meaning citizens and ordinary residents. A state, in the exercise of its jurisdiction, also has the power to enforce those laws to us, as well. A state has the power and the jurisdiction to try us for violating those laws. Now, the three examples that I just gave earlier actually relate to three types of state jurisdiction. The first is legislative or prescriptive jurisdiction, and that relates to the power of a state to make laws that apply to all persons and things within its territory. At the same time, administrative or enforcement jurisdiction would refer to the power of a state to enforce its laws against all persons who contravene them. And judicial or adjudicatory jurisdiction would refer to the power of a state to try anyone within its territory for violating its law. Now, let's examine some jurisdictional problems this time. Now, the problem in international law concerning jurisdiction arises when the action of a person, or if there's an issue over a subject matter, and there would be two or more states that would seek to exercise jurisdiction over the same person, issue, or subject matter. So let's assume, for example, that there is an Australian who has gone to Syria to fight in the Syrian conflict there, whether as part of the rebel groups or as part of the army, for example, of Bashir al-Assad, who is the president of Syria, or even to get involved with one of the groups under ISIL. And Australia, in the exercise of its legislative or prescriptive jurisdiction, may then pass a law that would criminalize such type of behavior. And if Australia did that, and assuming that those same acts, which might be defined as terrorism, are similarly prohibited and penalized by the state of Syria, if that Australia, therefore, is arrested, the question then is, who has jurisdiction over the acts of terrorism as defined by both the states of Australia and Syria? And in that case, you have an instance of a jurisdictional conflict, because you have both Syria and Australia trying to exercise jurisdiction over the same act of terrorism and involving the same Australian subject. And a very good example of a jurisdictional problem occurred in the case of the 1988 Lockerbie incident, which involved the downing of an American airliner, which was Pan Am Flight 103, which had traveled on the 21st of December 1988 to Detroit from Frankfurt, Germany, via London and New York. And what had happened was that there had been two Libyan nationals who planted a bomb in the plane. And as the plane was flying over Lockerbie, Scotland, the bomb exploded, which killed all the 243 passengers, as well as crew members of the plane. In addition, there were also 11 other people on the ground in Lockerbie, Scotland, who died as a result of the plane crashing on the ground. And so therefore, if you examine the victims and the casualties of that airline crash, there were 188 Americans who died, as well as 80 other individuals who belonged to 21 other states who died from the plane explosion and crash. And eventually, the two Libyan nationals, who were actually not on board that plane, but they were able to plant the bomb anyway, these two Libyan nationals eventually were arrested. And so you can just imagine, therefore, the question of who had the jurisdiction, for example, to try these two Libyan nationals. On the one hand, you can have the Americans seeking to exercise jurisdiction because it was an American airliner that had been blown up. and as well as the fact that there were 188 Americans who died as a result of the bombing of the plane. The UK would also seek to exercise jurisdiction over these two Libyan nationals, mainly because some of its people also suffered deaths. I mean, those Scottish citizens who, the Scottish individuals who had died as a result of the plane crashing on the ground, these were obviously UK subjects, and so there was basis, therefore, for the UK state or the UK government to try to exercise jurisdiction, as well as the fact that the plane blowing up, this had occurred in the airspace and the territory of the UK. So that, again, there was factual and legal basis for the UK to seek to exercise its own jurisdiction over the two Libyan nationals. It can also be said that Germany could exercise jurisdiction, not only because there were some German nationals who died in the plane crash, but also because one of the main elements of the crime of terrorism or the planting of the bomb had occurred in Germany, because that's where the bomb had been planted. And of course, there were 21 other states that could seek to exercise jurisdiction over the two Libyan nationals who were responsible for the bombing on the ground that their citizens had died from the Lockerbie incident. Now, the question there, so if we examine the states which could claim jurisdiction over the incident, any of the 22 states whose nationals died as a result of the incident could claim jurisdiction. Obviously, the United States also could seek to exercise jurisdiction, because Pan Am is an American airliner, and there were 118 Americans who died in the plane crash and the bombing. The UK again could seek to exercise its jurisdiction because the incident occurred in its territory, as well as the fact that there were UK citizens, 11 UK citizens, who died on the ground. And then obviously Germany could seek to exercise jurisdiction because an essential element of the crime, which was the planting and the planning and the planting of the bomb, occurred in Frankfurt, Germany. Now, but the question is, if you examine, therefore, the jurisdictional principles that would have been the basis for any of these states to claim jurisdiction, we will observe that they would have sought to apply jurisdiction on the basis of different principles. In the case of UK, it would be on the basis of the territoriality principle, as well as in the case of Germany. Germany could claim that it could exercise jurisdiction because the essential elements of the crime of terrorism or planning and planting of the bomb had occurred within the territory of Germany. We will also observe that for most of the states that would have tried to seek jurisdiction over the two Libyan nationals, they would have done so on the basis of nationality, in the sense that they would have argued that because of the deaths of their own nationals, then they could seek to exercise jurisdiction over the two Libyan nationals. There's the protective principle in this case doesn't really apply, and we'll examine why in a short while. The universality principle also will not apply. The passive personality principle, as we will notice, potentially could apply. And we will examine these jurisdictional principles in the next PowerPoint slides. So let's begin with the territoriality principle. So as I earlier gave us an example, Lord Macmillan in Compagnia Naviera Pascongado versus Steamship Christina had said that it is an essential attribute of the sovereignty of this realm, as of all sovereign independent states, that it should possess jurisdiction over all persons and things within its territorial limits. And so therefore the idea that a state has territorial sovereignty over its jurisdiction is a principle that has been recognized since time immemorial, mainly because it is understood that a state should have full, supreme, and plenary power over its own territory without being subject to the influence or interference of any state. And given this recognition that a state, or every state, should have the full and plenary power over its own territory, it also means that it has the unbounded power to pass laws that apply within its own territory. And the only recognized limits would be in relation, for example, to the principle of state sovereignty, which we will examine in greater detail next week. But what the principle of state sovereignty tells us is that a state, another state, cannot be the subject of proceedings in the courts or forums of another state. So, for example, it would be a breach of international law for an Australian court to seek to try a case that has been filed against the government of China, for example, if in that case the action or the litigation relates to sovereign acts of China. So when I speak of sovereign acts, so these would be government acts. So it could be about procurement of military weapons. It could be it could have something to do with the operations of the Chinese government itself. So if these activities of the Chinese government, which are sovereign or governmental activities, had as a consequence resulted in a potential breach of contract or harm to another person, and that person then files suit in a court of Australia, that Australian court would, under international principles, be prohibited from entertaining such a suit against the Chinese government because of the principle of state immunity. And of course, we already know that the other principle, which seeks to limit the exercise of state jurisdiction, would be in relation to the immunity of accredited diplomats of foreign states. So based on treaty law, particularly the Vienna Convention on diplomatic immunities, the accredited diplomats of states are free from arrest by a host state. Otherwise, a host state that seeks to arrest them would be in breach of its treaty obligations under the Vienna Convention on diplomatic immunity. Now, given the fact that it is a well-recognized principle that there is territorial sovereignty by a state, what it suggests is that a state may pass laws that, for example, would prohibit free speech. It can even impose restrictions on the practice of religion. And if that state wanted to, it can impose punishment by stoning, caning, hanging, or even public flogging. And in that case, another state cannot seek to interfere or question the legality of such legislation passed by a state because of the principle of territorial sovereignty. Now let's examine another principle, and this is the nationality principle. And what the principle tells us is that international law recognizes the power of a state to exercise its jurisdiction on its nationals, even though these nationals happen to be abroad. So these nationals can be abroad because they live there permanently or because they travel there. And in the example that we gave, it would be permissible, for example, under the rules of international law, to pass laws that would criminalize behavior by Australians for activities that they do or commit outside of Australia, for example, by engaging in acts of terrorism in Syria. What it also tells us is that international law recognizes the validity, for example, if Australia were to penalize or to pass a law that would make it criminal for an Australian to commit pedophilia or engage in child sex, such as in Thailand or the Philippines, even assuming that these acts may actually be legal even in these other countries. So it would still, under the nationality principle, be permissible for Australia or for a state to pass laws that would apply to its nationals, even if the actions of these nationals occurred outside of its own territory. So that is according to the nationality principle. And part of this principle is the understanding that it is for a state to decide and determine who are its nationals. And two, it would not be permissible for a national to simply try to unilaterally shed or renounce his or her own citizenship or nationality for the purpose of trying to evade the laws of his or her state of nationality. So, for example, an Australian who can be held liable for committing acts of child sex or child trafficking, say in Thailand or the Philippines, cannot just then say that he has renounced his Australian citizenship in order to avoid being held liable by Australian criminal laws. It would still be Australia that would still have ultimate power to determine the application of its laws on its nationals. Now, the third principle concerning the exercise of state jurisdiction is what is known as the protective principle. And what this suggests is that, and the basic question that we have here is that, can a state claim jurisdiction over a foreign national who commits a crime abroad? So in the example we gave earlier, under the nationality principle, international law recognizes that it is permissible for a state to try to apply, to seek the application of its laws extraterritorially to its nationals abroad. But in this case, in the scenario that we're trying to deal with, the question really relates to whether or not a state can claim jurisdiction over a foreign national who commits a crime abroad. And so in this case, the territoriality principle obviously would not apply, since the crime was not committed in the territory of the state. And at the same time, the nationality principle would not apply because the person who is involved is, in fact, a foreign national. And a good example to examine is the case of United States versus Zehe. So in this particular case, Alfred Zehe was a German physicist. He was a professor as well as an author and a German citizen. He was accused by the United States of committing acts of espionage for the former East German government. So there was a time when there was an East Germany as well as a West Germany. Obviously, these two states are now just part of the new Germany that we know now. And so Alfred Zehe had been accused by the United States of committing acts of espionage. And these acts of espionage actually did not even occur within the US. So in this particular scenario, Alfred Zehe is not a US national. If he committed acts of espionage, the acts had happened not in the territory of the US, but in fact, it happened in Mexico. And the US was then trying to apply its US espionage law against Zehe. Now, Zehe had come to the US to attend a symposium, and while he was there, he was arrested and indicted in a U.S. court. Zihi sought to have the indictment against him dismissed on the ground that the U.S. has no jurisdiction over him. One, because he is not a national of the U.S., so the nationality principle doesn't apply. And secondly, the alleged crime did not happen in the U.S., but it happened in Mexico. But the U.S. district judge ruled against Zihi and said the courts expressly relied upon the nature of the offenses and not upon the citizenship of the defendants in order to apply other criminal statutes extraterritorially to foreign citizens. So under the protective principle, therefore, there are instances when it is permissible for a state, in order to protect its security, to pass laws that would apply to its non-nationals for acts being committed abroad. So let's say if there were some Chinese individuals or let's say Russian hackers that may seek to attack the websites of banks of Australia, and these are considered harmful to the security and the financial interests of Australia, for example, then the Australian state or the Australian government can argue that it can criminalize such behavior under the protective principle, which is recognized in international law. Now let's examine the fourth principle. And so the question is, can a state assert jurisdiction for a crime? One, if that crime cannot be regarded as a threat to the state security and the operation of governmental functions. In that case, the protective principle will not apply. And let's assume that the crime is committed by a national. So therefore, again, the nationality principle will not apply. And let's assume that the crime is committed outside of its territory. So again, the territoriality principle will not apply. So let's look at specific examples. So by now, you may have heard me talk about the current president of the Philippines, Rodrigo Duterte. I say here that only 3,000 drug addicts or drug suspects have been killed since Duterte took office in June of this year. And so this year being 2016. In fact, there are about 5,000 drug suspects already who have been murdered by the police, by the policemen of Rodrigo Duterte in what is known as state-sponsored extrajudicial killing. So in the Philippines now, if somebody is suspected of being involved in drugs, not just somebody who sells drugs, but somebody who uses drugs. So meaning if somebody is presumed to be a drug addict, or not even a drug addict, just a drug user, a user of an illegal drug, that person can be summarily killed by the police or the death squads of Rodrigo Duterte. The question is there some way for Duterte to be held liable criminally under international law? The other question we might ask would be, you've probably heard of ISIS and ISIL. That refers to the group in Iraq and in Syria, where they've tried to proclaim the Islamic State of Iraq and Syria. And what they've done is actually to butcher thousands of soldiers of the Assad regime, as well as civilians. The question is, would it be permissible, for example, for the United States or even Australia, assuming that one of these members of the ISIS state or ISIS military were to visit Australia or the US, can they be seized and arrested by Australia or say the US if either of these countries would pass a law that would criminalize these particular acts of murdering soldiers, even if it wasn't in the course of combat, or even the killing of civilians. And in like manner, would it be, and what if the Assad regime has in fact been responsible for murdering civilians and rebels as well? Because even in Aleppo and other rebel strongholds in Syria, what the Assad regime has done to try to drive off these rebel groups has been to drop barrel bombs in civilian areas controlled by these rebels. And as a result, it has led to thousands upon thousands of deaths to civilians, including to women and children. And the question is, would it be permissible for a state such as the US, Australia, or let's say New Zealand, that for any of these states to pass laws that would make it criminal for somebody from ISIS or the Assad regime to have committed these acts of mayhem and murder? And so that if any of these people from the Assad regime were to visit Australia, the US, or New Zealand, they would then be arrested. Would it be permissible for these states to pass the law? Now, if we examine the universality principle, we know that international accepts that there are certain crimes which are of such universal concern to the community of nations that any state may exercise jurisdiction over and prescribe punishment for them. So such crimes would include piracy, slave trade, attacks or hijacking of aircraft, genocide, war crimes, and perhaps certain acts of terrorism. And this principle was recognized by the Privy Council in Re Piracy Juri Gentium, as well as by the Permanent Court of International Justice in the case of France versus Turkey. So going back to that question of Duterte and ISIS and ISIL, for example, the question is, do you think that the universality principle can apply so that any state may pass a law that can make Rodrigo Duterte, for example, liable for the crime of genocide? Now we go to the final personality concerning the final principle concerning jurisdiction, and that pertains to the passive personality principle. And so let's extend the question further, the question we had in section 3.4. So can a state assert jurisdiction for a crime that cannot be regarded as a threat to state security and the operation of governmental functions? And what if the crime as well is not of universal concern to the community of nations? In other words, it's not genocide, it's not piracy, it's not hijacking. And let's assume that the crime was committed by a non-national and that the crime was committed outside of its own territory. The question is, would it be permissible for a state to pass legislation to seek to assert still jurisdiction for such a crime? And under the passive personality principle, and this principle obviously is a bit controversial and not well accepted in international law, although as you will see, the US has in fact been applying this principle. So under the passive personality principle, a state may assert its jurisdiction over a non-national whose acts affect or harm its own national, so even though such acts are committed in another state. So, for example, the United States may pass a law whereby if an American is harmed, say, in Brazil or harmed in Russia by a Russian or by a Brazilian person, the United States would then make it a crime, so that this Russian or even this Brazilian who commits crimes against an American national can then be subject to the jurisdiction of the United States. And the passive personality principle was first applied in the case of United States versus Cutting, or the Cutting case, wherein Mexico arrested, imprisoned, and charged Mr. Cutting, who was an American national, with libel for publishing some defamatory materials in the US about Mr. Barade, who was a Mexican diplomat. So this is an example of the first application of the passive personality principle, where Mexico arrested and imprisoned a non-national who was an American for committing certain acts that harmed a Mexican, even if these acts actually occurred outside of Mexico. Mr. Cutting, however, was eventually released following negotiations between the US and Mexico. Now, the passive personality or victim principle is asserted by some states as a way of trying to protect their nationals who are abroad. So the assertion of jurisdiction is based on the fact that another person outside a state's territory has injured one of its own nationals abroad. So while there is some opposition, very strong opposition to the extraterritorial application and reach of a state's laws on the basis of the passive personality principle, there is in fact some support for it in relation to some acts such as terrorism and organized assaults on the diplomatic or other officials of a state abroad. And so after studying this topic, you should now be able to discuss and explain the meaning and nature of jurisdiction and the principles on which jurisdiction is based.